You're sitting in your car after a long shift, scrolling through your notifications, when red and blue lights flood your rearview mirror. The flashing lights reflect off your phone screen, and suddenly, you're wondering what happens if the officer asks you to hand it over. Your entire life is in that device: texts, photos, bank accounts, and private conversations. It's completely normal to feel a tight knot in your stomach when someone with a badge starts asking questions, but you've more power here than you might realize. Tonight, we're breaking down exactly how the law treats your phone during a police encounter, step by step, so you know exactly where you stand. First, you need to understand the baseline rule. The Constitution gives you a massive shield against the government, and it's called the Fourth Amendment. This is the rule that says police can't just rummage through your stuff whenever they feel like it. To look through your private property, they generally need a warrant. A warrant is a specific permission slip, signed by a judge, that gives officers the legal right to search your belongings. Because your smartphone holds the equivalent of millions of printed pages of personal documents, the Supreme Court decided that a phone isn't just a simple piece of property, it's fiercely protected. If an officer wants to search your phone, they almost always have to go get one of those judge-signed permission slips first. So, let's walk through the actual steps of what happens when you're standing on the side of the road. The very first move you make in this sequence is figuring out exactly where you're legally. Are you free to walk away, or are you being detained? Detained means you aren't under arrest, but the officer is keeping you right there temporarily because they suspect you might have done something illegal. If an officer stops you for a broken taillight, they can ask for your license and registration, but they can't demand your phone just because you're sitting there. If the officer asks, "Can I take a look at your phone?" you don't have to hand it over. The law calls this a consensual encounter. Consensual means you agree to it freely, without being forced or threatened. If you hand over your phone and nod your head when they ask to look through your photos, you just gave up your Fourth Amendment shield voluntarily. You don't ever have to consent to a search of your device. The best way to handle this is to stay perfectly polite, but clearly say, "I don't consent to a search of my phone." You aren't being difficult or hiding something. You're just using the rulebook exactly as it was written to protect your private life from an unlawful fishing expedition. But what if the officer just snatches the phone out of your hands while you're detained? That brings us to the next step in the sequence, which involves an exception to the rule. It's called search incident to arrest. This is a legal rule that lets officers search you and the area immediately around you when they put you in handcuffs. Historically, they did this to make sure you didn't have weapons or evidence you could destroy, but the Supreme Court drew a hard line in the sand here. Even if you're placed under arrest, the police still can't search the digital contents of your phone without a warrant. They can physically take the phone out of your pocket for officer safety so you can't grab a weapon, but they absolutely can't start swiping through your apps and messages. That leads to the next critical move, because some officers might try a different angle to get inside your device. They might rely on a rule called exigent circumstances. Exigent means there's an extreme, immediate emergency where evidence might be destroyed or someone is in immediate physical danger. For example, if they believe you just sent a text to a partner who is about to commit a violent crime, they might claim an emergency to bypass the warrant requirement. But this is a very narrow exception. It isn't meant for routine traffic stops or casual investigations. If the police take your phone without a warrant and start digging around without a genuine ticking clock emergency, they're stepping way outside the boundaries of the law. Now you need to know how the physical security of your phone changes everything. This is where modern technology meets old legal rules. You're standing there in the street, and suddenly the officer pulls out a piece of paper from their cruiser. It's a search warrant. A search warrant is a powerful court order that completely overrides your Fourth Amendment shield. If a neutral judge signs this paper, it means the judge looked at the facts and decided there's probable cause to believe a crime was committed and that evidence of that specific crime is sitting inside your phone. Probable cause means there are enough reliable facts to make a reasonable person believe a crime occurred. If they hand you that warrant, you must comply. You don't get to physically fight them, and you don't get to grab the phone and run. The warrant gives them the legal authority to search, even if you know you're completely innocent. The fight over whether that warrant was valid doesn't happen on the side of the road. It happens later, in a courtroom, with a trained attorney who knows the local system. When you're standing in that high-stress moment, keep your actions simple and focused. Ask the officer if you're free to leave. If they say no, you're being detained, and you don't have to answer any questions or agree to any searches. If they say yes, calmly pack up your things, secure your phone safely in your pocket, and walk away from the situation. If they demand the phone, politely ask if they have a warrant. If they don't have one, keep repeating that you don't consent to any searches of your property. Every single interaction is recorded or monitored, and your calm, collected behavior will be the strongest evidence if the officer crosses the line. You might be wondering what happens if you get arrested and the police take your phone into the station overnight. There's a specific rule about seizing a phone versus searching a phone. Police can seize a phone, meaning they take physical control of it to prevent you from remotely wiping the data. This is standard procedure if they suspect the device holds evidence of a crime. But the magic word is still warrant. They can hold the physical phone in a secure evidence locker for hours or even days while they draft a warrant application, but that digital vault stays completely locked until a judge gives them the green light. If they start digging through your digital life during that holding period without a judge's signature, they're breaking the law. This entire system relies on you keeping your head cool while the pressure is on. The side of the road isn't a courtroom, it's a collection zone. Officers are trying to collect evidence, and they'll use social engineering, intimidation, or just plain confusion to get you to hand over your rights on a silver platter. They might say things like, "If you've nothing to hide, why won't you just show me?" This is a classic tactic designed to make you feel guilty for using the exact rights you were born with. Innocent people have the exact same rights as guilty people, and exercising those rights is never a crime. You aren't obstructing justice by refusing a search. You're simply demanding that the government follow its own rulebook before it invades your private life. But remember, state laws and local court decisions can vary wildly. What a traffic cop does in a rural county might be completely different from what an officer does in a massive city, and state constitutions sometimes offer even more protection than the federal one. That's why having a basic map of how the rules work is a great starting point, but you should never try to act as your own lawyer if things go south. The moment your phone is seized or you're placed in handcuffs, your next phone call needs to be to a local criminal defense attorney. A lawyer knows the specific local rules, they know the local judges, and they can tell you if the officer actually had the legal right to do what they did. They can also file motions to suppress, which is a formal request to a judge asking them to throw out any evidence the police found illegally. Have you ever been in a stressful situation where you weren't sure if you had the right to say no to an authority figure? Tell me down in the comments. If this breakdown helped you understand exactly how your digital privacy works when the lights are flashing behind you, share this video with someone who drives every day and might need to know the rules of the road. And make sure you subscribe to Scribble Law so you always know the actual rules of the game before the system tries to peek into your private life.